Hi, I'm Emily and I am here with Maya Murphy's attorney, H. Daniel Murphy. Attorney Murphy practices at Maya Murphy's law offices in both New York and Connecticut. My question today for Attorney Murphy is, what is covered by child support in Connecticut?
Child support in Connecticut is money that's paid from a non-residential or non-custodial parent of a minor child to the custodial parent, someone with whom a child lives most of the time, as long as the other parent is located. In other words, the party has to know where the other parent is, and it does not have to be in the state of Connecticut for child support to be ordered. And as long as a court order on child support actually is issued. There might be voluntary payments that are made in the spirit of child support, but they don't actually become child support payments until there's a court order on the subject. And child support orders and child support payments can be retroactive for a period of time, meaning if they hadn't been sought previously, there are certain mechanisms that can compel child support to be paid back in time for time that already passed. There are certain child support guidelines in the state of Connecticut which tell the court and the parties how much child support to award in a particular case. And there's a calculation that's performed that's not covered here, which gives the court some guidance as to what child support figure is appropriate for the parties in that particular instance. But the question is often asked about what child support is intended to cover. Child support is intended to cover a portion of food, clothing, and shelter. I say a portion because the formula itself is intended to cover both the custodial parent and the non-custodial parent's share of those expenses. And they're divided essentially pro rata according to the proportion of the net disposable income that each party has. Child support also applies to cover regular health care costs for the child, as well as other expenses related to a child's entertainment and basic educational costs. So what I mean by that, as far as basic educational costs, school supplies, back to school shopping, school uniforms, textbooks, tutor costs, lunch money. But the reality in Connecticut, certainly in Fairfield County, is that basic child support obligations are often insufficient to cover the costs of extracurricular activities for the children, or educational expenses for that matter, such as private school. So for that reason, parties in Connecticut should expect that courts can and often will consider those extra expenses when they're fashioning court orders. And in the case of something like extracurricular expenses, parties should expect that there will be some sort of sharing of those expenses, maybe on a percentage basis, but usually with a safeguard providing that there has to be some kind of mutual understanding or agreement or consent to incur those expenses for the child. So a conversation I often have with divorcing parties is that if soccer for a child is historically something that the child has always enjoyed and has done consistently, the parties should expect that that particular expense would be shared in some proportion on a going forward basis. But if one party, let's say after divorce, unilaterally decides that the child should spend a year at a boarding school in France, and that has never historically been done, that would likely not fall under ordinary child support. And absent some unusual and particularized showing, that's a type of expense that would not necessarily be ordered by a court to be shared or taken on at all. If a minor child in a custody matter that you're dealing with has unusual expenses or expenses that are considerably above what the presumptive child support figure would be after you're applying the guidelines, the parties would best be served by sitting down and speaking confidentially with an experienced family law attorney about what courts do in these types of situations.
Attorney Murphy is available 24/7 and can be reached by calling 203-221-3100. You can also email Attorney Murphy at hdmurphy@mayalaw.com, and please visit mayalaw.com for more information.